Good afternoon, everyone. Thank you so much for joining us this afternoon. I'm due to be presenting with my lovely colleague Lisa Byers, but she's had some sort of travel-related emergency, so I'm sure she'll be joining us soon. But you're stuck with just me for the moment. For you, those of you who I've not met, my name is Rachel Mackay. I'm a director in our employment team, and I will, as I say, hopefully be joined by my colleague Lisa very soon, who's also a director in our employment team. And I/we are very excited to be speaking to you today about the joys of the Employment Rights Bill, the ever-evolving Employment Rights Bill. Uh, I'll come on to an outline of what we're going to discuss this afternoon shortly, but just a few housekeeping matters in the first instance. Could I have the next slide, please, Maria? Lovely. You should automatically be on mute, but if you're not, please do pop that on now just to minimise any background noise. If you've got any questions, please feel free to pop those in the chat, and I/we will of course do our best to answer them during the course of the session, if time allows. We might be tight on time, so if we're not able to respond to your queries during the session, we can collate them and come back to you separately, if that would be helpful. Of course, as with everything employment rights bill related, much is TBC at the minute. So if we don't have answers, we can get them for you, or please do direct them to the House of Commons or the House of Lords as appropriate. Uh, I should say, and I mentioned that you can put questions in the chat, but as you'll appreciate, we can't on these calls provide tailored legal advice. But if you do have any specific questions relating to your own organisations, please do get in touch offline and we'll be delighted to assist you. Finally, I do just need to make you aware that today's session is being recorded, and a recording will be circulated to you all after the session if you have a burning desire to listen to this again. So today, as you know, we're going to be providing you with an update on the progression of the Employment Rights Bill and what changes to employment law you can expect as a result in the coming years. We did do a law lab back in July, so we won't be covering off old ground in terms of the content that was discussed during that session. But please do reach out if you weren't able to attend and you'd like a recording of that, and we can certainly provide you with it. We're going to start by examining the implementation timeline to update you on when reforms are expected, and then we'll look in more detail into some of the changes proposed by the bill. Today we'll be focusing on just a few of the matters covered by the bill, bearing in mind it's so far-reaching. So we'll be focusing on parental and paternity leave, statutory sick pay, the new harassment duties, the new proposed day one protection, and finally we'll have a look at some of the open and upcoming consultations. And indeed, I've got some exciting breaking news to share on that. So first, current progression of the bill. The progression of the bill is being described by pretty much everyone as parliamentary ping pong, which I really enjoy. I mean, it's exactly that, isn't it? You know, back and forth between the houses without a huge amount of progress. I don't think you'd help me for summer. I don't think you'd thank me for summarising that whole ping pong match, and we don't have time for that today. But I'll focus on some of the key points from the latest update in terms of the House of Lords. So most recently, the bill was passed back to the House of Lords for further debate on the 17th of November, and the Lords voted to make a number of amendments to the bill. So firstly, in relation to the qualifying period for unfair dismissal, which is a biggie, I think. So firstly, as you'll be aware, employees currently need 2 years service in order to bring an unfair dismissal claim. The government made a manifesto commitment to make unfair dismissal a day one right, so a huge departure from the current position. However, during the report stage in the House of Lords, the Lords passed an amendment that would have required a 6-month qualifying period, so a little bit more comfort for businesses there. And this has gone back and forth, ping pong style, between the House of Commons and the House of Lords on a number of occasions now. With the Sorry, I just got an email from Lisa. She will be joining us soon, I'm delighted to say. So with the House of Lords, the House of Commons insisting on day one rights, and the House of Lords insisting on the 6-month qualifying period, with neither house kind of moving significantly or at all from those respective positions. The latest update is really no exception to that, with the House of Lords still insisting on that 6-month qualifying period. The House of Lords are certainly of the view that a qualifying period will provide necessary security for employers, whereas a day one right would have an adverse effect on hiring decisions, and in their view would adversely affect, for example, young workers and those returning from career breaks, because those individuals are, in their view, more likely to be viewed as higher risk hires. So there we have it. That's the latest update on the House of Lords and the qualifying period for unfair dismissal. Moving on to guaranteed hours. So the House of Lords have been looking at guaranteed hours contracts. The government made a manifesto commitment to end what they called one-sided flexibility by banning 0 hours contracts. The latest from the House of Lords is that employers should be required to make a guaranteed hours offer unless the worker declines or opts out. So there's a slight difference from what's originally proposed in my view. But that exact same amendment was previously rejected by the House of Commons. So expect further ping pong. Next, they looked at the trade union ballot threshold. So currently, as a number of you will be aware, the turnout threshold for industrial action is that at least 50% of the trade union members entitled to vote must participate in the ballot. The government's position is that the 50% turnout requirement places an unnecessary burden on unions, whereas one of the Lords has described the 50% threshold as an important line of defence against industrial action chaos in workforces. In short, the latest update is that the Lords remain of the view that 50% turnout requirement for industrial action ballots should be retained. Next step, so the bill is going to have to return again to the House of Commons, and the ping pong continues. Appreciate I'm kind of hammering that metaphor to death now. It's not clear how much longer this back and forth will go on, when the bill will receive royal assent, or how it will affect the implementation timeline. Lisa, do we have Lisa yet? No. Lisa's going to take us through the roadmap, but let me just skip
Not
to.
yet.
No problem. We can skip to parental and paternity leave, please, Maria, if you can find that slide. And we'll come back to the roadmap shortly. Thank you. So yes, I mentioned one of the points in the Employment Rights Bill that we were going to discuss today is in relation to parental and paternity leave. So it's anticipated that from April 2026, unpaid parental leave and paternity leave will become rights from day one of employment under the Employment Rights Bill. So this is, as you'll know, a change from the current position in which employees require at least 26 weeks of service for paternity leave and at least 1 year of service for unpaid parental leave. By way of reminder for those not familiar, parental leave it's a statutory entitlement of up to 18 weeks of unpaid leave per child, and it's available to parents and others with a parental responsibility. And the purpose of the leave is that it should be used only for caring for a child. The bill, the Employment Rights Bill, abolishes those service thresholds that I just outlined, meaning that a new hire could request parental leave or paternity leave or both without having to gain any specific length of service. Importantly, it also proposes to remove the restriction that currently prevents someone from taking paternity leave after shared parental leave, which is a bit of a peculiarity in the current interplay between shared parental leave and paternity leave, and that previously that wouldn't have happened. So in other words, once shared parental leave has been used, a return to paternity leave may become possible. So all of that feels like, a small step in the right direction in terms of family friendly rights, but it has been criticised as certainly not going nearly far enough. Importantly, we should remember that the Employment Rights Bill, it doesn't introduce a day one right to paternity pay, and parental leave remains unpaid under the Employment Rights Bill. So the practical impact, I think, for employees is relatively limited, particularly when you consider that paternity leave remains at a 2-week entitlement. That said, even though it's not a significant shift in my view, there are of course steps that organisations should be taking to ready themselves for these changes. So as is the case with a lot of these ERB changes, I think manager training and policy reviews will be key. In particular, if your organisation's policy allows for enhanced paternity pay, consideration will need to be given as to whether that too will become a day one right under your organisation's own policy, in line with the day one right to paternity leave. Next slide, please, Maria. Thank you. Um, the next point we're going to cover under the Employment Rights Bill is statutory sick pay. So this is another important anticipated reform in the Employment Rights Bill. Currently, only employees who earn above a certain threshold are eligible for statutory sick pay, and even then, statutory sick pay usually only begins from the fourth consecutive day of sickness, with the first 3 days being unpaid. However, under the Employment Rights Bill from April 2026, this would become payable from the first day of sickness absence, and the lower earnings limit that currently excludes some very low earners from SSP will be removed. So yeah, it removes the 3 day waiting periods and that lower earnings limit requirement. And of course, with these limits removed, a broader range of employees will be entitled to sick pay and more absences will be paid from day one. Taking a step back and looking at all of that from a practical perspective, firstly, and perhaps completely obviously, this change has financial consequences for businesses and for employees. With a lower earnings limit gone, more workers, especially part-time, low-paid or variable hours workers, will become eligible for statutory sick pay. Also, paying statutory sick pay from day one significantly increases costs, particularly if some employees tend to take very short absences or one-off days off, whereas previously that wouldn't have triggered statutory sick pay in the absence of a company sick pay that enhances that. They would be entitled to statutory sick pay from that first day under the current proposals in the Employment Rights Bill. So businesses will, of course, need to consider the impact of that and plan or budget for a possible increase in sick pay related expenditure. I think also from a practical perspective, just be mindful of your payroll systems and your absence management systems being updated to take account of that day one right to statutory sick pay if that passes as expected. Excuse me while I scroll. Maria, could you pop down to open consultations, please? Lovely, thank you so much. Just skipping past, Lisa's going to cover some of the other topics, so harassment and unfair dismissal, but just popping down to open consultations at the minute. So you may have seen in the news that pretty recently the government initiated a series of consultations on select reforms outlined in the Employment Rights Bill. I think just before I kind of get into the detail of those, I think there can be a bit of confusion about why we're seeing consultations pop up this late in the game. The thing with the Employment Rights Bill is that it kind of sets out this broad overarching framework for a lot of these changes, but then at various points within the bill gives the Secretary of State the power to make regulations at a later date, which will set out the detail of how all of this will actually work. So in these consultations, the government is seeking views on that more granular detail about how all of this is going to work in practice. The 4 consultations that were launched recently, I'll go through those in a minute. Those remain open. I'll go through the closing dates if you have a burning desire to contribute to them. So the first consultation seeks views on trade union right of access. The ERB will give trade unions the right to access workplaces. The relevant provisions will enable independent trade unions and employers to enter into what's going to be called access agreements for union officials to access the employer's workers, whether that be digitally or face-to-face in the workplace, for a wide range of purposes, but not, importantly, not to organise industrial action. This latest government consultation seeks views on the operational detail of how that right of access will work. The government seeking views on a number of proposals, including, I just kind of picked out which I thought were the most interesting, how requests for access and responses to requests should be made. Is it proposed that they will need to be made in writing? Presumably so, that seems sensible. Also seeking views on the time frame during which employers must respond to those requests and the level of detail that must be provided in that response. For example, are they going to be required to give reasons for the rejection? I suspect so. And the government's also seeking views on how fines for breach of an access agreement should be calculated. So, important to bear in mind that fines can be applied. That consultation closes on the 18th of December, so get your responses in sharpish if you wish to contribute. The second consultation relates to the duty to inform workers of their right to join a union. So the Employment Rights Bill will require employers to give workers at the start of their employment and at other times a written statement advising that they have the right to join a trade union. And the government intends that this duty will be brought into force by October 2026. This individual consultation seeks views, pretty similarly to the last one, on how that new requirement can be implemented effectively while minimising the burden on employers. So it seeks views on, again, a whole number of things, the content of the statement, the form the statement could take, the manner in which the statement must be delivered, and the frequency with which the statement must be reissued after the beginning of employment, noting that it's not just a start of employment obligation, there's a kind of rolling obligation to provide employees with this written statement. And again, that consultation also closes on the 18th of December this year. Shameless plug time, and forgive me for this, but just before I move on to the two open consultations, or the two remaining open consultations that I'm going to speak about, we do have a subgroup of specialists within our team who have significant experience of advising clients on all aspects of industrial relations, whether that's dealing with trade union recognition requests, industrial action, pay negotiations, so that the full spectrum of industrial relations matters. We are definitely seeing a real increase in the number of requests for assistance with change management projects. Huzzah! Lisa is here. Welcome, Lisa.
Good morning. I'm so sorry. I'm going to be talking about the ping pong between the House Lords and Commons, and I just feel like I've been on ping pong all morning. So thank you, Rachel, for plugging away. Have you just skipped
Not
your
at
bit? Have
all.
you skipped onto yours?
Yeah, well, I'm actually in the middle of giving a shameless plug for our
Oh,
trade unions
great. I love a
subgroup of
shameless plug.
specialists, of which Lisa is a member.
I've
So
joined
this is
just in time.
well timed, well timed. So I will conclude my shameless plug, and we're just going through the open consultations section, and then I'll pass back to you just to start at the roadmap, and then go through your remaining topics, so
Great.
harassment and unfair
So
dismissal.
perfect. Amazing. I will
Lovely.
go on mute just now then.
Okay, thank you. So yeah, as I was saying, we as a team, and Lisa can attest to this, we're seeing a real increase in the number of requests for assistance with change management projects, which I'm sure has been prompted at least in part by these upcoming changes under the Employment Rights Bill. The bill will, and this is something that was touched on in the last Law Lab, I believe, it will significantly restrict an employer's ability to make changes to T's and C's once it comes into force, and its impact on the industrial relations landscape will certainly be significant. Our team have acted in some of the largest change projects in the UK. So if you have any concerns on your radar, please do reach out and get in touch with Lisa, ideally, and she will be delighted to assist. No, do reach out to your usual contact, and we can assist you with any of that. The third consultation that I'm going to speak about deals with enhanced dismissal protections for pregnant employees and new mothers, and this is a chunky, significant one in my view. So the Employment Rights Bill contains powers for the government to make regulations about dismissal for reasons other than redundancy during or after a protected period of pregnancy or statutory maternity leave, or indeed, any other form of family leave. Late last month, the government launched a consultation on the various options for enhancing protection against dismissal for pregnant women and new mothers. The consultation, again, as with the others, seeks views on a really wide range of matters. I think this one is particularly wide, including whether the 5 existing potentially fair reasons for dismissal should continue to apply for pregnant women and new mothers in their current form, and whether the availability of each of those potentially fair reasons should be narrowed or removed entirely. That's a really significant one in my view. And whether a stricter tailored test should be introduced to assess the fairness of dismissals for any of the existing potentially fair reasons for dismissal. Curiously, Unlike the previous two consultations that I just mentioned on the trade union side of things, the government doesn't express any preference in relation to any of those options that I've just outlined in the consultation document, so that it really seems wide open, this one. That consultation, you've got a little bit longer if you'd like to contribute to it. It closes on the 15th of January. And as I say, this to me feels like the most impactful or significant subject matter under consultation, at least in terms of the open consultations. Um, the proposal that each of the five potentially fair reasons for dismissal might be removed entirely, that feels really quite radical and such a significant departure from current law. I'll be really interested to read the response to that consultation, and we'll be sure to keep you all updated. Finally, last consultation from me is the consultation on bereavement leave, including pregnancy loss. So the Employment Rights Bill will amend the Employment Rights Act, which currently deals with parental bereavement leave, and the ERB will amend it to widen the scope to cover bereavement more generally, so not necessarily just parental bereavement leave, and that will include pregnancy loss before 24 weeks. This government consultation seeks views on, again, a number of matters relating to this change, including eligibility criteria. So what kind of relationship must the worker have with the deceased in order to qualify for bereavement leave, whether that's grandparents, cousins, etc., siblings. It also seeks views on when and how leave can be taken, so including how much leave should be available, and also views on notice and evidence requirements. So how much notice must be given and will evidence be required? That latter piece, the requesting of evidence in a bereavement situation, feels like a tricky one to handle. And again, that consultation, you've got a little bit longer for that one. That closes on the 15th of January. I will pass back to you, Lisa. I've got a little bit of content on some upcoming consultations if there's time, but I'm keen that we pass back to you on the roadmap in the meantime.
Yeah, absolutely. That sounds good. So, yeah, I'm going to go back. Are we able to go back slides? Oh, yeah, someone's on it. Perfect. Okay. So, yeah, I'm going to talk about the roadmap. So, really, so when does the bill become law? So, first off on this, you'll see that, well, for the bill to become law, it needs royal assent, which it does not yet have. Once royal assent is received, the bill will become law. But however, as we've mentioned in very many previous law labs, that the effect of many of the reforms within the bill will be delayed and there'll be a staggered sort of implementation over the next few years. There's going to be a few important things to keep in mind as part of that implementation stage, particularly from the point of royal assent. The implementation dates will become much more fixed. So what we're seeing is many employers are sort of considering briefing their leadership teams. They're looking at updated project plans, and at this stage about the potential implications that we may see from what we anticipate coming along. We're looking at some undertaking some comprehensive internal audits, looking at policies, onboarding materials, training programs, etc., that are likely going to need to take place in the sort of implementation period of time. Next, we would have after royal assent. So it is expected that some changes will come into force as soon as 2 months after royal assent. The majority of these changes would concern trade unions, which I know that we've covered in depth at the Employment Law Lab in July. But just as a quick reminder, the changes that were expected during or we're expecting during this wave of implementation would be strengthened protections against blacklisting, removal of the industrial action ballot turnout threshold, reduction of the period of notice of industrial action, which is required to be provided to the employer from 14 days to 10. Provisions which will allow the implementation of electronic balloting for industrial action will be put in place. So from a practical standpoint, it's just important to review in advance, all record keeping policies, etc., prior to royal assent to make sure you're on top of those developments. Next on the roadmap, we're looking at April 2026. So there were further reforms expected or anticipated then, and these will include the day one right to unpaid parental leave, a day one right to paternity leave, and potentially the ability to take paternity leave following shared parental leave, a right to statutory sick pay from day one of sickness, and removal of the lower earnings limit for SSP, which, Rachel, did you cover that? Have you still to do that? Have you done the SSP
I
bit?
have.
You have, great. Okay, that's efficiency. Okay, so we've gone into the detail of that. There's going to be provisions which will allow the threshold for statutory union recognition to be lowered from 10% to anywhere between 2 to 10. Sexual harassment disclosures will be deemed to be public interest disclosures. Protective award for failure to properly consult, and a collective redundancy increase from 90 to 180 days. So they're the ones that are anticipated in April. There will be another in October, quite significant proposed anticipated changes. So as it stands, that's going to include the new employer duty to take all reasonable steps to prevent sexual harassment, which I'm going to go on and talk about. A new employer duty to take such steps as are practicable to prevent third-party harassment of employees. It's fair to say that that's probably one of the key areas we're seeing employers preparing for at the moment. We've got the extension of time limits to bring a tribunal claim from 3 months to 6 months. Rachel, I'm sure you agree. I'm not sure how the tribunals are going to cope with that, given that we're getting hearing dates in now that are 2 years away. So that will be interesting. There's going to be strengthened protections against detriment for taking part in industrial action, enhanced rights to time off, and facilities for union representatives, including trade union officials, learning representatives, and equality representatives. It's important to note the majority of these duties are active and not passive, so there's going to require a lot of action on employers, and we'll need to explore that in more depth shortly.
I was just going
And
to pitch in there, Lisa,
yeah,
just because it's maybe a good moment when you'd mentioned the extension of the time limit from 3 to 6 months. Um, it was pretty recently announced, and this isn't an employment rights bill thing, but it's relevant. Particularly in terms of what you just said about tribunal delays. But it's been pretty recently announced that the early conciliation period
Gas.
is increasing from 6 to 12 weeks. So, as many of you will be aware, before raising claims, an employee for some time now has been required to go to ACAS to conduct what's called early conciliation, which is essentially an attempt to resolve the matter before it even reaches tribunal. And the maximum period for that currently is 6 weeks, but it's being extended to 12 weeks from, I think it's the 1st of December, so very, very soon. Um, and I think the intention behind that is to ease pressure on ACAS because, like the tribunals, they're just coming under so much pressure, aren't they? But all it's really doing is kind of pushing it further down the line when we're already seeing such significant delays in tribunal. You know, Lisa and I can see sometimes we're seeing claims being listed well in excess of a year after a claim's
Yeah.
been lodged. So it's increasing that period further. But I guess I just flag it because I think sometimes there can be that tendency to think, or previously used to think, nice one, it's been three months since like this dismissal occurred and we haven't received a claim, we're in the clear. And then early conciliation was added on, so you had to add on that period, and now that's been increased to 12 weeks. So just something to be mindful of.
Yeah, no, that's absolutely right, Rachel. I think that part of it was that a lot of employers were just receiving the certificate on the desk and not even realizing that the matter had gone to ACAS because ACAS were so overwhelmed. Um, yeah, so 2027, so the remaining changes to be brought in by the ERB will come in force in 2027. Many of them are subject to the government consultation, so they could change, but the most important anticipated ones are unfair dismissal protection from day one, an enhanced employee right to request flexible working, a new right to bereavement leave, potentially including pregnancy loss, enhanced protections against dismissal after statutory family leave, pregnancy, and maternity leave, and a new duty on employers to offer guaranteed hours and provide reasonable notice of shifts, changing the way 0 hours contracts function. Um, so that's really a sort of whiz through the roadmap, and obviously much of it is all still sort of TBC, but that's sort of what it very much is sort of anticipated at the various sort of stages of the implementation process. I'm now going to move on and sort of dive into a bit on harassment. So I'm going to touch on sexual harassment and most specifically the fact that the bill introduces a strengthened proactive obligation on employers to prevent sexual harassment in the workplace. As I'm sure you'll all be aware, the proactive obligation came into force in October last year. This is going to change in the sense that it will change from reasonable steps to all reasonable steps to prevent sexual harassment from October 2026. So, I mean, what does that mean? It's going to mean that employers are going to be expected to demonstrate that they have, made active, considered, and ongoing efforts to minimise risks of sexual harassment. So you're unlikely to meet that threshold by simply with a policy or one-off training that has been developed in the past, and that really you're going to have to actually have the prevention of sexual harassment and a robust integrated strategy on that. We will are anticipating, I think, Rachel, I think it would be fair to say an increase in claims as well, potentially off the back of that. From my own looking at stats more recently, even since the introduction of the duty last October, the first half of this year saw an increase of 39% in sexual harassment concerns making their way to ACAS. So I think that, when we're looking at an even further enhanced, protection, and the reintroduction of third party harassment, which I'll come on to talk to, there's likely to be an increase in matters making their way to ACAS on this. So practical tips, yeah, first and foremost, I'd say we say risk assessment. Undertaking a risk assessment is going to be key to meeting this duty. The purpose of the risk assessment would be to, well, first examine the potential risks within your business. So that could include looking at, well, lone working, um, confined physical layouts, isolated working environment, high stress working, night working, power imbalances, um, dealing with emotionally distressed service users. There's a variety of different factors that will need to feed into that, and it will completely depend on, the sector and that you're operating in, and where your employees are based and working. Um, After you've identified those risks, what you'll then need to do is, well, what measures can we implement what can we do to mitigate these within the workplace? Risk assessments should be documented formally. They'll need to be reviewed, and they should be revisited whenever work patterns or team structures change, or there's a shift around in, how your business operates or where it's operating from, for example. Next on the list would be policies. So having an anti-harassment policy, if you have one already, that will need to be checked and updated to ensure it covers sexual harassment expressly. If you don't have one, you'll need to have one that covers both. These policies should sort of set out how an employee can raise a concern, including informal and formal reporting routes, reassurance on confidentiality for those that are either reporting, for anybody reporting a concern of sexual harassment, whether that's sexual harassment of themselves or sexual harassment that they have perhaps witnessed in the workplace. And it should also set out the investigation process so that employees can understand what will happen, and, so that they can fully appreciate what's going to happen next when a report is made. Um, Next, training on sexual harassment. So, as we always say, and you'll hear us probably harp on all the time, is that, training can't just be a tick box. It will need to be kept up to date, it needs to be refreshed, and it needs to be tailored to your workforce. It's really important for this sexual harassment training to be provided to all staff. But what is even more important is that managers should be given additional training, given their position within the workplace. They need to be able to recognize, forms of harassment, and they need to understand how to respond appropriately to that when an employee raises a concern, and how to navigate those really difficult conversations that come out of these really sensitive, issues that can arise within the workplace. Without sort of seen as, sort of diminishing or minimizing the issue at hand. It's really quite tricky to navigate. We do think that, manager training on that is only beneficial. Reporting systems. So ensuring that you've got robust reporting systems in place, if you don't have already. So this will involve establishing potentially multiple channels to enable employees to report concerns. So this could be either designated HR contacts or anonymous reporting tools or external, hotlines. And you need to make sure that all those channels are communicated, to your employees, and that you do make sure that they remain, accessible at all times. Um, I think one of the key things I take from all of this is it's just what you need to make sure is you to have your employees feeling that they're safe to report concerns, and it's essential, in order to demonstrate that you have these policies and procedures and training in place. Um, So key pitfalls. So what could fall short of this new robust duty? I mean, the first one here goes without saying. So generic and outdated policies. So relying on off-the-shelf wording that doesn't reflect your organization is just not going to cut it. Um, you need to have something that, mirrors and it works for your workplace. Number two would be assuming that because you've had no complaints, you will have no problem. Low reporting levels, for example, could be because people don't feel that they can report the matter. So you really need to be taking these sort of risk assessments and rolling out those policies so everybody's quite clear that they can and should report any instances of potential um, harassment. Um, Ignoring cultural risk factors. Um, so allowing sort of problematic environments to persist. I think we all have seen, these issues arise in workplaces, whether that be seen as banter, etc., and sort of not normalizing that behavior. One thing I do think that we'll see a bit more of is, for example, when you have employees leaving the business and they are raising as part of their exit interviews, concerns about, oh, this happened in the workplace, that happened in the workplace. I think that there's going to be a heightened obligation, for you to look at that and to consider what you then need to do off the back of that sort of disclosure at the end of employment potentially. So moving on to third party harassment, this is a
Lisa,
really
there's sorry to interrupt.
yeah.
I've just spotted a couple of sexual harassment related questions in the chat box that I thought we could pick up here.
Yeah,
Well,
of
I think
course.
certainly the second one relates to sexual harassment. I think the first one do
Oh
does as
yeah, I
well.
see
So
them. Yep.
can this be applied on Christmas company events? Yes, absolutely. To the
Mm-hmm.
extent that those that those events are an extension of the workplace or workplace related. So yeah, absolutely. I think, Lisa, chip in if you disagree, but what
No,
we're
I
talking about
agree.
in terms of, risk assessments, planning ahead and training, etc., are equally applicable in relation to those. And you'll be familiar with the kind of pre-Christmas party fun police email that you often get about maintaining appropriate conduct during Christmas parties. So that would apply equally here. Um, and then next, would you recommend sexual harassment training to be conducted separately, or is doing so as part of wider DEI training sufficient? Um,
I mean, I think as long as it's going to come down to the content of the
mhm.
training, to be honest, I think that you could roll it into a wider DEI training, but I think what's going to be critical really is going to be that the training that you provide is fit for purpose. So you're going to have to make sure that it's tailored, it's got examples, you're putting scenarios in there for everybody to work through, I think is what would be key. And you're spending enough time on the issue to be able to show that you're treating it with the seriousness that the tribunal would expect for you to be able to rely on that, moving forward if you needed to.
Thanks. Sorry for interrupting you.
Okay. Third party harassment. Yeah. So I think this is going to be this is a really significant change, because it's going to potentially make employers liable if you have an employee and your employee is harassed by, for example, a customer, client, patient, service user, contractor, or even member of the public. It's going to be particularly relevant in retail and hospitality sectors, but it's also going to be in any workplace where there's a high level of contractors. So, I mean, I do a lot of work within the energy sector, so that is one where there's a high level of contract workers, but you're also looking at sort of construction and infrastructure sectors as well. So I think it's going to be there's going to be certain areas where it'll certainly um, hit hardest. Again, the practical tips from that, without laboring the same points, but a risk assessment is going to be one of the key ones there. So that's going to be looking at examination and assessment of the settings in which your employees are interacting with third parties and identifying the factors that may increase the likelihood of harassment in those circumstances. Um, Policies, you'll need to make sure that they're updated to explicitly address third party harassment. So they should be outlining, well, what constitutes unacceptable behaviour by third parties. It should provide employees with guidance on how to seek help, and it should explain the steps managers can take when incidents would occur. Um, they should also describe, the potential consequences for third parties, such as, being removed from the premises, barred from returning, or, potentially in very serious incidences if they do occur, reporting the matter to the police. Um, There would be training again, so that would be training for looking at including recognizing early warning signs, de-escalation techniques where appropriate, and how to look out for colleagues and report incidents safely. Um, I think that training's just going to be a critical, important element of it, and it's going to be factoring that all in and the relevance of third-party harassment and how that, where the risks arise from the workplace and what your managers would need to know to be able to identify and address those and raise any potential concerns regarding that. Some other important points that I think are certainly noteworthy would be, you need to be carefully considering the wording of contracts with third parties, and suppliers, and what might need to be added in, whether that be about adhering to respectful behaviour standards and or any relevant policies that you would have and the consequences, of any breaches of those. I think it's going to be important to understand what training anybody, any contractors, or any other workers have had on sexual harassment before they're admitted onto your site. And I have seen some employers that we are working with adding signage to the workplace as well, just about appropriate standards of, behaviour as well. Some of the key pitfalls to avoid. So treating third party behavior as outside the employer's control would be one of them. Making sure, as I said, that anyone you allow access on your site has had training and is aware of your policies and procedures on sexual harassment. Poor incident recording, so it's really going to be important to make sure you're keeping detailed records. If you don't, it makes it impossible to identify trends or to demonstrate compliance with the statutory duty. So that's going to be important. Lack of escalation for repeat offenders. So allowing problematic third parties to return or continue to interact with staff, even if you know there have been incidents before. That's just something that there could be an ongoing risk there that you're exposing the business to. Um, Normalizing abusive behavior. So accepting difficult or abusive customers as being, well, this is just part and parcel of the job, kind of, and could undermine the duty to protect staff and may increase, legal exposure. So that's the high level summary of third party harassment. I'm now going to move on to unfair dismissal. So I repeatedly keep hearing this being referred to, and I don't know if you've heard it, Rachel, is the day one rights, day one rights. I don't know if you've heard that one.
No, but we're having all of the fun employment law related buzzwords
I know
or
we do come up
terms
with the
today.
best ones, don't we? Anyway, so currently, you'll probably all be aware employees must have 2 years qualifying service to bring an unfair dismissal claim, unless, of course, they're able to bring a claim of automatically unfair dismissal on one of the statutory grounds or a discrimination complaint. I mean, we have, and as employment lawyers, we have seen a variance in the qualifying period, over time. And that qualifying period has always been used as a bit of a buffer to assess, by employers to assess the suitability of, new hires and, without fear of the unfair dismissal claims after that period. But yeah, it's going to make, ERB will make, or it's proposing to make the protection from unfair dismissal a day one right. I don't know, you may or may not be aware, but the proposal has been subject to much parliamentary sort of ping pong at the moment between the House of Commons and the House of Lords, with the House of Lords saying, well, we don't agree. We think that there needs to be a qualifying period, but it should be a shorter qualifying period of 6 months. And then we have the government saying, no, 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 we promised that we would have day one rights. We need day one rights. So at this point, the government's not conceding and is insisting on day one rights. So we will need to wait and see what happens next. But it seems unlikely that the government are going to backtrack on that. Um, when would this come in? When, as I said earlier, it wouldn't be until 2027. And whilst that means there's time to prepare, it's going to be a very significant change. And so early consideration of the impact of that on hiring and dismissal practices is going to be critical. Um, One thing to be clear is the day one right will not apply to employees who have accepted an offer of employment but not yet started work. So this prevents claims of unfair dismissal arising where an employment contract is terminated by an employer after it's come into existence, but prior to the employee starting work. Um, so whilst it will abolish the qualifying service, the bill will is also going to provide for employers to be able to dismiss more easily in the earlier months of employment, specifically during what's being referred to as an initial period of employment, or where notice is given during the initial period of employment and expires no more than 3 months after that period. So the initial period has become known as, or it's been referred to as a statutory probationary period, and its likely purpose is to make new employees who are not quite right for the job less onerous, to still sort of factor that in. At present, it's going to be, well, at present the government's preference is that it would be a 9 month period. Um, and these changes will only apply where the dismissal is related to the employee's capability, statutory restriction, conduct, or SOSR. So it's quite important to remember that redundancy is not included on that list, and therefore employees being made redundant during the initial period of employment would still have the right to claim, would still have that right there. Um, Whilst the employee will still be able to claim unfair dismissal, we're waiting on regulations to be laid down, which will allow for the lighter touch standard of fairness in respect of dismissals during what I've already referred to as the initial period of employment. So it's anticipated that there will be regulations, and essentially what the government will explain is what steps that you will need to take within that initial period of employment that will allow you to successfully defend any claim. But no specifics have quite yet be confirmed, but there have certainly been hints and indications that may involve, a meeting with the employee at which they'll have the right to be accompanied to discuss whatever the concerns are, whether that's conduct or performance. So, practical tips. Um, so whilst it's not yet enforced, some of the key things to be thinking about are, well, first off would be probationary periods. So it's, carefully considering, what length should you have as any probationary period. It doesn't necessarily need to be the same period or same length as the initial period of employment, but if the initial period of employment is set at 9 months, you need to ensure that, any probationary period allows time for early review of performance and other required steps so that you can ensure that any decision is correctly implemented before the end of the initial period of employment. Contracts drafting. So I think it's going to be really important to ensure contracts and offer letters include the probationary period. Should looking to clearly make sure that's clearly articulated in offer letters and contracts to give new hires clear expectations and keeping clear records of the employees' signed contract. We all know that they seem to go missing, or it's harder to keep track of them, but it's going to be, I think, quite important to make sure you've got confirmation of their agreement to the probationary period. Robust process and management. So yeah, I mean, this is going to be one of the key potential challenges, is sort of making sure that your managers are keeping on top of things during that is going to be one of the key takeaways. So what you might want to be thinking is, do we need more training for our managers for how to manage and performance during that sort of early period, so that we can have a structured process in place so that we can make sure that by the end of that, if the person isn't right for the job, then we're going to be in a good place to be able to, terminate employment. Um, Pre-employment. I think this is one of the things that there's going to be a bit of a focus on, maybe. And Rachel, I don't know, maybe you'll disagree, but I just see that given that there's going to be these day one rights, I think a lot more focus is going to be added to the start of the process to really, are we employing the right person? Are we doing enough checks at the outset? Are we going to tweak that process? Do we want to have more of an interview or a selection process and get training on our managers about, how to go through that process? Because you do want to ensure that you're getting, well, as best as you can, that you're getting the right fit for the job. But I mean, that being said, you're still going to have to take on board the sort of potential discrimination and making sure that, there are necessary adjustments made and consideration is still being given to that during the recruitment process. But I think that's going to be one that we will see. I don't know, what do you think, Rachel? Just with, given that there's going to be this day one right, is the the intense, potentially a bit more intense pressure on making sure that you pick the right candidate.
Oh, 100%. And I think if I try and look at the positives of it, if you look down the line, and if this day one right is revoked at some later stage, perhaps this new rigorous recruitment process that everyone will have put in place will be hugely helpful just in terms of hiring the right people from the get-go. But I do think there is potentially a detrimental impact on certain portions of the workforce. Like I mentioned earlier, particularly younger employees who don't necessarily have the experience. You often see job adverts already that say,
Agreed.
you
Yep.
need not apply unless you have X amount of experience. And you think, well, how do I get the experience if I can never get a job? And I think that's just only going to get worse because the fear of employing someone who's not quite right partially or wholly because of their experience will be heightened. So definitely
Well,
challenges
yeah.
there.
Yeah, it may impact on any sort of DEI, diversity in the workplace sort
Exactly.
of targets, etc., that you're setting. Yeah, that is a good point
Hmm.
as well, Rachel. Um, so just summarising key pitfalls to avoid. So some of the key takeaways would be under documenting performance. So just make sure that you're keeping good records, you've got warnings, feedback, and review outcomes. If you don't have those, it can leave you vulnerable to unfair dismissal claims. And this is, even though calling out poor performance is tricky, we all know that it's best to just to make sure that you've got a fair and robust process in for doing that. Um, Inconsistent practices. So, without a clear standardized probation policy, different managers may apply different standards, leading to perceived or actual unfairness. Lack of clarity in contracts. So, if your probation terms are ambiguous, employees may argue that your process is unfair or not what they were offered. Um, and ignoring the risk post probation. So even if someone passes probation, you should keep performance under review at all times and be flagging any performance issues to ensure you can fall back on your actions in the event of any tribunal claim. So I think that takes me through all the unfair dismissal ones, Rachel. Did you have anything else? I mean, we're literally cutting it fine on time, but I don't know if
Yeah,
you had anything else to finish off with.
yeah, but I've got I teased everyone with some very exciting breaking news at the
Well, we
start
don't
of
want to let them down.
no, no, I couldn't possibly. I was just going to. I talked a lot about consultations earlier on, and thanks everyone for bearing with me through that. But there are some proposed future consultations, the vast majority or all of which I believe fall after the proposed royal assent date. But I saw an update this morning that I think previously we'd been told that there were going to be in the region of 7 new consultations in the future in relation to the Employment Rights Bill covering various different topics. But it was announced yesterday, I believe, that there are now going to be 26 consultations. So that's, I think, one of the most widespread consultation exercises we've ever seen. And there's been some commentary already that potentially that is because of, and forgive me for using this phrase again, that parliamentary ping pong and the difficulty with getting this passed through the House of Lords, that actually, if they increase the consultations and give the Lords comfort that the kind of finer detail will be dealt with through 26 consultations, that may assist in getting everything passed sooner. So yeah, if you're a fan of consultations, good time to be alive. Good. Well, I don't see any other questions in the chat box. So, unless anyone wants to put in a little last minute one, I just want to say thank you very much for joining us through that speedy trot through the Employment Rights Bill. As always, please don't hesitate to get in touch with our team if you've got any specific questions that you prefer to take offline, and we'll be delighted to assist you with that. And also look out for our Employment Law Lab bulletin, which will contain a summary of what we've discussed today.
Great. Thank you all. Thanks for coming.
Thanks for joining. Have a great day, everyone.